Specifically, this presentation will cover what a prior art rejection is, an introduction to the specific requirements pertaining to prior art, and how that prior art may be used in a rejection. We will base this training on the following understandings. The first understanding is that claimed inventions are presumed to be patentable unless you, as the examiner, are able to establish some basis to the contrary. In other words, a claim is patentable unless you are able to show why it is not patentable. In order to be patentable, a claim must meet a number of requirements, the most important of which are outlined in 35 U.S.C. sections 101, 102, 103, and 112. The second understanding regards the level of proof needed to establish that a claim is not patentable. In the examination process, the examiner may make a prima facie case that a claim is not patentable in order to shift the burden to the applicant to either provide evidence to the contrary or to amend that claim. To make a prima facie case, the examiner provides sufficient evidence to make fact findings supporting a determination of unpatentability. Anticipation, or novelty, is discussed in 35 U.S.C. 102, whereas obviousness is discussed in 35 U.S.C. 103. Because we use prior art to establish anticipation and/or obviousness, rejections under 35 U.S.C. sections 102 and 103 are referred to as prior art rejections. We will now discuss how prior art is used to show anticipation or a lack of novelty. In patent law, the word anticipation refers to something that has been foreseen or known beforehand. In order to make a prima facie case that a claim is unpatentable because it is anticipated, we must provide facts, supported by evidence, that establish that the claim's subject matter was known beforehand. We must point out where each and every element of that claim was taught in the prior art. In other words, we must show that the claim was not novel. There are several different types of evidence that we may use to establish anticipation or obviousness. This module focuses primarily on the references type of evidence and how references can be used under 35 U.S.C. 102 and 103. References typically refers to documentary evidence. We divide these references into three groups because the statutes treat them differently. The first group is U.S. patent documents, which include granted U.S. patents, U.S. patent application publications, which are also known as PG pubs, and certain publications of PCT, or Patent Cooperation Treaty, applications designating the United States. The second group is foreign patent documents, which includes granted foreign patents and published foreign patent applications. The third group includes all other publications, whether in print, on microfilm, or online, and includes documents such as digital media, websites, electronic databases, and so on, that are neither U.S. nor foreign patent documents. We refer to this category as non-patent literature, or NPL. Admissions refer to statements by the applicant that acknowledge something to be prior art to them. These admissions can be made in the application itself or during the prosecution of the application, in written remarks or orally, often in the form of, or along with, arguments. Affidavits and declarations are sworn statements, always in written form. Affidavits and declarations are usually provided to us by the applicant, but the person making the statement can also be someone other than an applicant or inventor, and can even be the examiner. Affidavits and declarations are often provided to introduce into the record some special evidence or opinion that is not conveniently found in any other published document. Knowledge in the art may be provided by logical analysis, or may be facts that are well known. Under certain limited conditions, facts alleged by the examiner to be well known may be entered into the record through a process called official notice. This presentation will cover prior art requirements, which treat the various types of U.S. patent documents, foreign patent documents, and non-patent literature documents differently. Other public disclosures, which may not have been recorded at the time of the presentation, or which may not be available in document form, can be acceptable forms of prior art in an AIA first inventor to file application. We will now turn our attention to prior art requirements for anticipation under the America Invents Act of 2011. There are only two subsections of the AIA that identify prior art. 35 U.S.C. 102 A1 and A2 set forth the potential disclosures that may be used to make a prior art rejection in an AIA application. Section 102 A1 sets forth three general types of disclosures that can be applied as prior art. First, patents and printed publications. Second, public uses and sales. And third, disclosures otherwise available to the public. Section 102A1 generally requires that the prior art disclosure have a public availability date before the effective filing date of the claimed invention under examination. However, both public and secret sale activities can be applied as on-sale prior art if before the effective filing date. Section 102A2 allows U.S. patents, published U.S. patent applications, and published PCT applications that name another inventor to be used as prior art if they were effectively filed before the effective filing date of the claimed invention under examination. Under 102A2, the effectively filed prior art date can be the actual filing date of the application that issued as the U.S. patent or published as the application publication. If the 102A2 reference includes any domestic benefit or foreign priority claim to a prior application, the effectively filed prior art date can be the filing date of such a prior application, domestic or foreign. Here are the types of 102A1 prior art stated verbatim. Regarding the first type, patented refers to issued U.S. patents as well as foreign patents in any language. Regarding the second type, under AIA 35 U.S.C. 102A1, there is no geographic limitation on where prior public use, sale, or offer for sale occurs. The public use, sale, or offer for sale would need to occur before the effective filing date of the claimed invention to constitute prior art under AIA 35 U.S.C. 102A1. The Supreme Court has stated that enactment of the AIA has not changed the meaning of on sale as it is used in Section 120. Thus, both public and secret sale activities can be applied as on sale prior art under 35 U.S.C. 102A1. Regarding the third type, the subject matter covered by otherwise available to the public expands the types of prior art that can be employed. It makes clear that other public disclosures, which may not have been recorded at the time of the presentation, or which may not have been available in document form, are indeed acceptable forms of prior art in an AIA application. We will now discuss the exceptions to 102A1 prior art. AIA, FITF, or First Inventor to File, Section 102B1 sets up exceptions to 102A1 prior art by establishing a grace period of 1 year following any disclosure made by or originating from the inventor or a joint inventor. Section 102B1 creates exceptions for grace period disclosures that would otherwise apply as prior art under Section 102A1. Section 102B1A says that if the disclosure being considered as prior art was made by or obtained from the inventor during the grace period, then that subject matter may not be used as prior art against that claim. Section 102B1B is sometimes called the prior public disclosure exception. This exception can apply to a third-party grace period disclosure only if there is an earlier grace period disclosure made by or originating from the inventor or a joint inventor. The relevant subject matter of the third-party grace period disclosure must have been previously publicly disclosed during the grace period by the inventor or a joint inventor, or by another who obtained the subject matter from the inventor or a joint inventor. No exception applies to Section 102A1 prior art dated more than 1 year before the effective filing date of the claimed invention. That's because a 102A1 prior art date more than 1 year before the effective filing date of examined claims is outside the grace period of the examined claims. Regarding the 1-year grace period, note that AIA applicants can rely on perfected foreign priority claims for the effective filing date of their claimed invention. Here are the 3 U.S. patent document references that can be used as references in 102A2 rejections: U.S. patents, U.S. PG pubs, and WIPO publications of PCT applications designating the U.S. WIPO stands for World Intellectual Property Office, which is the organization that publishes PCT applications 18 months from the PCT filing date or priority date. When it comes to U.S. patent documents resulting from PCT applications under AIA 102A2, there is no requirement that the WIPO publication be in English in order to use the PCT application filing date as a 102A2 prior art date. The date a U.S. patent document was effectively filed is the 102A2 prior art date for that U.S. patent document. Section 102D defines effectively filed. In accordance with Section 102D1, the effectively filed 102A2 prior art date can be the actual filing date of the application that issued or published as the U.S. patent document. However, in accordance with 102D2, if the application that issued as the U.S. patent or published as the PG Pub or WIPO publication claimed domestic benefit or foreign priority to an earlier application, the effectively filed 102A2 prior art date is the filing date of the earliest such application that describes the subject matter. For example, the 102A2 prior art date of a U.S. patent is the actual filing date of the application that issued as the patent if the application that issued as the patent had no domestic benefit or foreign priority claim to an earlier application. If the application that issued as the U.S. patent did claim domestic benefit of one or more earlier filed U.S. applications, or claimed priority to one or more foreign applications, then the 102A2 prior art date is the earliest such application that describes the subject matter relied upon to make the rejection. Notice that foreign priority dates of U.S. patent documents can be applied as prior art dates under 102A2 when examining AIA cases. Now let's discuss the exceptions to 102A2 prior art. 35 U.S.C. 102B2 provides exceptions to the use of certain U.S. patent documents as set forth in Section 102A2. The first two exceptions of Sections 102B2 are similar to the two exceptions of Section 102B1 that apply to grace period prior art. The 102B exceptions apply to using U.S. patent documents that would otherwise qualify as prior art as of their effective filing dates. Under the 102B2A exception, a 102A2 reference is not prior art as of the effectively filed date if the subject matter disclosed was obtained from one or more members of the inventive entity, either directly or indirectly. The 102B2B exception applies to U.S. patent documents that would otherwise qualify as 102A2 prior art, similar to how the B1B exception applies to third-party grace period disclosures that would otherwise qualify as 102A1 prior art. Section 102B2B provides that a third party's U.S. patent document, which would otherwise qualify as prior art under Section 102A2, may be disqualified as prior art if the subject matter disclosed had, before such subject matter was effectively filed under subsection A2, been publicly disclosed by the inventor or a joint inventor or another who obtained the subject matter disclosed directly or indirectly from the inventor or a joint inventor. This prior public disclosure exception can only be effective if the inventor originated prior public disclosure was within the grace period. Otherwise, the prior public disclosure would itself be 102A1 prior art, for which no exception could apply. We'll discuss the third exception to 102A2 prior art next. The third exception is the only exception to 102A2 prior art that has no counterpart exception for 102A1 grace period prior art. The 102B2C exception provides that a disclosure made in a U.S. patent document shall not be prior art to a claimed invention under Section 102A2 if, not later than the effective filing date of the claimed invention, the subject matter disclosed in the U.S. patent document and the claimed invention were owned by the same person or subject to an obligation of assignment to the same person. The 102B2C exception does not apply to a U.S. patent document disclosure available as prior art under AIA 35 U.S.C. 102A1 as well as 102A2. In other words, if the issue date or publication date of a U.S. patent document is before the effective filing date of the claimed invention, the 102B2C exception is ineffective. Many times, a U.S. patent document that can be applied in an anticipation rejection has both a 102A2 date, the effectively filed date, as well as a 102A1 date by way of an issue or publication date within the grace period of the examined application. Because the 102B2C applies only to 102A2 rejections, the best practice is to apply any anticipatory U.S. patent document with a grace period issue or publication date under both 102A1 and 102A2. Another reason for applying anticipatory U.S. patent documents with a grace period issue or publication date as prior art under both 102A1 and 102A2 is because an applicant's own public disclosure may be an exception under 102B1B by being prior to the issue or publication date of the U.S. patent document, but may not be a prior public disclosure relative to the effectively filed date of the same U.S. patent document. In such a case, the prior public disclosure exception would not be available under 102B2B, even though it is available under 102B1B. 35 U.S.C. 102C sets out the conditions for a joint research agreement that are required in order for the exception in 35 U.S.C. 102B2C to apply on the basis of a joint research agreement that was in effect on or before the filing date of the claimed invention. Any disclosure that has been found to be prior art under the criteria of 35 U.S.C. 102 can be used in an anticipation rejection regardless of whether or not the disclosure is analogous or disparaging. These concepts will be discussed in greater detail in future training. Next, we will discuss how prior art is used to establish an obviousness rejection. Recall that an anticipation rejection under 102 must point out where each and every element of that claim was taught in the prior art. A rejection under AIA 35 U.S.C. 103 is used when the claimed invention in an application is not identically disclosed or described, but the differences between the claimed invention and the reference teachings would have been obvious to a person having ordinary skill in the art. We make 103 rejections by explaining how a similar piece of prior art might be modified to arrive at the claimed invention. An obviousness rejection may be based on two or more pieces of prior art. In the example shown here, a claim has four limitations, A, B, C, and D. You find a primary reference describing A, B, and C, but not D. You find a secondary reference describing D. Thus, all four limitations were publicly available, but would it have been obvious to combine them? Since this module is an introduction to the concept of prior art rejections, we will just point out some highlights. There will be additional training to provide further details. First, prior art that is available for an obviousness rejection must qualify as prior art under the corresponding version of 35 U.S.C. 102. Second, there should be factual support for each and every element in the claims, either explicitly or inherently, even though more than one disclosure may be needed to establish that support. Third, the rejection must consider the claimed invention as a whole. Additionally, even though a disclosure qualifies as prior art, in order to use it in an obviousness rejection under Section 103, it must also be analogous art. There are two independent ways that a disclosure can be considered analogous. The first type of analogous prior art is when the prior art disclosure is from the same field of endeavor. The second type is when the disclosure is reasonably pertinent to the problem faced by the inventor. There is more training on this to come. To show obviousness, the combined prior art references, or the modified single reference, must teach or suggest all claim limitations, and it must have been obvious to a person having ordinary skill in the art to combine those claim limitations. The ultimate question is, would the claimed invention as a whole have been obvious to a person having ordinary skill in the art? This slide covers the 4 factual inquiries established by Graham versus John Deere that need to be made when making or reviewing a 35 U.S.C. 103 rejection. First, you must determine the scope and contents of the prior art. Then, determine the differences between the prior art and the claims. Next, determine the level of ordinary skill in the pertinent art in order to determine whether those differences would have been obvious. Then, there may be evidence of secondary considerations, such as the commercial success of the claimed invention, the claimed invention's ability to fulfill long-felt but unsolved needs, or the failure of others to solve the problem solved by the claimed invention. Note that evidence of secondary considerations are relevant only to obviousness rejections under 103, not to anticipation or novelty rejections under 35 U.S.C. 102. To write a proper 35 U.S.C. 103 rejection that employs both a primary reference and a secondary reference, follow these 4 steps. First, describe what the primary reference teaches relevant to the claimed invention. Then, identify the differences between the claimed invention and the primary reference. Third, indicate what each secondary reference teaches relative to the differences. Fourth, explain how the primary reference is to be modified by each secondary reference to arrive at the claimed invention, and provide the rationale for making each modification. An examiner must explain why each modification or combination of prior art teachings would have been obvious to a person having ordinary skill in the art in order to support the legal conclusion of obviousness. We need to remember that you, as the examiner, bear the initial burden of establishing a prima facie case of unpatentability based on either anticipation or obviousness. Prior art is employed to make rejections under 35 U.S.C. 102, anticipation, and 35 U.S.C. 103, obviousness. You should now be more familiar with understanding what prior art is and the basics of how it is used in determining patentability.